Please be seated. We have one case on the docket today in the matter of TVT, and that's cause number 14-18-00807-CV. Thanks to the Texas Supreme Court, this is back before us again on the constitutionality. Do the parties, can you announce for the parties, please? Ellen?
Sure, Stephen Jackson from the TVT.
Thank you, Mr. Jackson.
Patricia McLean for the state.
Thank you, Ms. McLean. Very good. Do you want to reserve any time for your rebuttal?
Yes, sir. Respect my reserve
5 minutes? Yeah. Okay, all right.
And please look for the microphone because the last time I was in oral argument, I don't think anybody could hear in the back.
I'll let the court know. I know where I have water. I went through cancer treatments over the past 6 months. I have to have water in the sleeves. I may make a couple of trips to do this. I'm not trying to be disrespectful. It's a new world for me.
Absolutely, no problem.
Just bring the water up to the podium.
Yeah, if you want to bring it
Sure.
up to the podium, that's fine.
Thank you very much.
Thank you.
May I proceed?
Yes, please.
Thank you. Justices, 5 years ago we were here, and I'll just briefly give you a quick background of the facts again. TVT.
Can you all hear out there? Because I'm kind of concerned about the live feed too.
I will do my best to speak
Well, I
out.
understand, but can
just speak
anybody in the
into the
back hear?
microphone.
Yes.
Okay, thanks.
Yes, sir. So TVT at the time was a 13-year-old Romanian immigrant whose parents won the lottery to come to the United States. He was accused in August of 2017 of sexually abusing another child who was 12 years old. And he was charged with aggravated sexual assault of a child under Texas Penal Code Statute 22.1021. The section he was charged under is for sexual assault of a child, which, as this court is aware, eliminates the ability to use consent of the complaining witness as a defense to prosecution. And this basically makes 22.021 a strict liability crime. Although it is not a statutory rape statute in and of itself, it is a statutory rape statute when applied to TVT. And our position, I think it is a much stronger as applied challenge. I know we had issues 3 and 4 on facial invalidity and as applied. The statute in and of itself for facial invalidity always fails in regard to children under the age of 14.
So at the trial court level, was the as-applied challenge presented to the trial court?
It was, Judge. In fact, it was an oral argument we made that position.
In the oral
I
argument
believe,
presentation?
Yes, ma'am. And also, it was also brought up, I believe, in the amended writ, the as-applied.
Okay.
It was the facial invalidity that we pulled out on the amended writ of habeas corpus. And so when we argued, we told the court we were encompassing all the facts in the law for each of the motion to quash, the dismiss, the summary judgment, and the writ of habeas corpus.
And so is it your position that the as-applied challenge is what the Supreme Court is asking us to examine today?
I think they sent it back on the constitutional issue of a whole. I don't know if they limited it to that.
Okay.
To answer your question best I can.
But in terms of the constitutional challenges, are there any other constitutional challenges besides the as-applied challenge that were brought up in the trial court?
I think that what was brought up, the oral arguments brought up due process, equal protection, although not specifically by those words, they were brought up. And the reason why is because under the 14th Amendment and those that were presented in the brief and also an oral argument is that we argue to the court that you don't know who the victim or the perpetrator is. And that gets into a vagueness issue and also gets into the arbitrary enforcement of this issue. And so what we made it a position with the trial judge and said, well, if you're playing doctor, and there was a quick response, what if they're playing fireman?
Yeah.
And it was a rough day.
I mean, we've been here before, so
yes,
we know the argument.
Sure, I appreciate that. And so, but when you have a situation where you don't know who to prosecute, a prime example, what if the district attorney's son and the sheriff's daughter engage in consensual sex? The sheriff's like, oh no, I'm going to go arrest the DA's son. They arrest the DA's son, the DA, you're not prosecuting my son, I'm going to prosecute your daughter. I'll take the daughter to grand jury. It leads to an arbitrary enforcement. And this can happen in every case when there's children under the age of 14. There is no way around it because You cannot say so-and-so consented to the sexual act. And as such, we believe children are...
Well, and this is not a situation where there's some other kind of objective physical coercion that happens,
So
which would tilt this. I understand that the statute's written the way it is, but there's not additional facts that would make this clearer.
And so the way I would address that, Justice Spain, is that if person A comes in and says, I'm charged with aggravated sexual assault of a child and I'm accused, I didn't do it. It was consensual, and of course the complaining witnesses, we have so many trials, one person says it was consensual, one person says it wasn't. Well, if you're 14 or older, that is a defense. But when you're under the age of 14 with a protected class of children, and I believe children under the age of 14 are a protected class, and there's 2 children under that age.
Well, let's just say one child has a knife that's pulled. I mean,
Yes.
this is not that situation.
Well,
right?
we don't know, right?
Or do we not? We don't
Well,
know.
and that's correct, you don't.
Actually, we do know,
Well,
there was a stipulation of the parties, wasn't there? And
There
actually a plea?
There was something, I believe, in the record as to the state would have said force was used. The defense that we told the court was that this was we were going to use a consent defense, but we would not be allowed to because we'd be arguing outside the law, which is not allowed. I would not give a jury instruction on this, and I'd be sending my client into peril, even though we believe the facts presented by the state would be unfounded. So even if there is let's say there's a gun, he holds it to the child's head, and the child consents to, he factually does consent, although he's not really causing the effect of the sexual act. The statute doesn't allow for you to defend it, and it also doesn't prohibit the prosecution of both children.
I'm confused. So,
Okay.
What you're saying is that, I think what we're trying to say is, correct me if I'm wrong.
Always.
Thank you. Is that if there was, whether or not there was any coercion, my understanding is that is not in the record about coercion, and I think that that's your question, right? About
Yes.
whether or not.
I think Justice Zimmerman, probably, I can't see unless the glasses go
Zimmerman,
up.
yeah.
that's all right.
apologize.
Good enough.
So, I think there was something that was alleged within the record, whether it was a probation, but there was something that might have referred to that.
In the record, the attorney referenced that begs the question of mens rea.
Yes.
So the question was whether or not the mens rea was an element of this crime or not.
And so, whether or not it's intentional and knowing. And so, yes, you can intentionally, knowingly commit this act, but if you intentionally, knowingly commit the act of sexual intercourse, oral sex, the dilemma is that's I don't think where the court needs to focus. It's the fact that, was it consensual? Well, you can't defend this.
Because there is no consent. The Supreme Court has already found, the Supreme Court has held in RRS that there is no consent available.
And they did. I think, I looked at this last night. I was up really late. I kept coming across something that is interesting. I think, respectfully, the justices in Austin may be looking at something that I'm looking at something different. What I'm looking at is this. I keep seeing a focus on the inability of TVT to consent, which that is an issue.
Yeah.
Can he consent to even having sex? And we looked at that, was it VW? I think with the prostitution case. But I think you have to also, importantly, shift the focus to the consent of the complaining witness.
A lack of consent turns something that could have been consensual in a normal situation into an assault.
Yes.
And I guess the gravamen of my, I'll use the $64 word, the gravamen of my question is like, we're not talking, we don't have facts before us that it's anything other than I have a baseball bat with me and threatening to use it. Or, I mean, this is all just, it happened.
Not that I recall.
Okay.
And so, and even if you did, I don't think it matters, because you still would be entitled to defend and say, that didn't happen.
Well, who said that he wasn't entitled to defend?
Because you cannot go in and utilize a defensive consent of child under the age of 14 when you can't. This is a strict liability crime. If you
Well, but it's a strict liability crime as presented by the judge in this case. But why wasn't testimony to some degree, even if just by the defendant, that there was some degree of consent or that it was lack of coercion?
Sure. There was in the oral argument that was put on that in the writ or the hearing.
Well, oral argument is not evidence, right?
I understand that.
Okay.
So the only thing I can tell you is that it was the position of the defense of the applicant at the court proceedings that consent was going to be used as a defense, but it would not be allowed. And as such, that was part of the basis of the written motions.
But there was no evidence presented at the trial during the writ hearing to bolster the consent.
That is correct.
Okay.
One of the biggest issues that I have here in a distinction between RRS and the TVT case is in RRS, it was actually a stipulation and agreement, and then an attempt to withdraw that agreement did not exist in this case. This was a case where there was a discussion with the judge, the trial judge, indicating, no, you can't put on that evidence, and yet there was no proffer of evidence from the trial court or from the defendant in this case.
I believe, and I've studied the RRS in the years since we've been here before. There was, I believe, a plea in RRS that was subsequently set aside.
No, it was an attempt to set it aside,
Okay.
but it was denied. And in that case, the Supreme Court actually said that the stipulation of the parties was sufficient to find guilt on the crime. The fact that they would not allow the withdrawal of that stipulation and plea was not, let's see, I think I have that. In the absence of any contrary record evidence, and I think that's what I'm focusing on, in the absence of any contrary record evidence, the juvenile's stipulation to the charges and admission to the allegations is sufficient on its face, or on its own, to support the trial court's adjudication of delinquency. So in this case, there was a stipulation, albeit after the judge denied the opportunity to put on a defense.
Yes, sir.
But there's no other contrary evidence that we have at this stage to indicate otherwise.
I would say that is correct, but I also believe that that would not be necessary to rule in our favor in this case. I don't think you would need those facts
Okay.
necessary to do that.
Could you just elaborate on that for?
Well, because I think, Judge, as applied to TVT, it would not matter if there was consent or lack thereof. It wouldn't matter if there was force or no force. In every situation with a child under the age of 14, as applied to children under this age, it always fails. Because you cannot argue consent no matter what, so it wouldn't matter.
But that's what RRS says, right? I mean, that's where we're kind of like stuck.
It
here.
does, but the constitutional issue is different. And the constitutional issue is you start looking at the minimal guidelines which law enforcement would enforce this statute, and by what ability they would do it.
Well, you're going back to the vagueness argument, right?
Yes.
But vagueness has to do with whether or not the enforcing officer has the right to determine who has actually committed a crime or not on a discretion as to who to prosecute.
I think that it goes hand in hand because you have to look at times, there's a case, Your Honor, that we came across, and it's out of the Ohio Supreme Court. And it's something we did not brief. However, the Ohio Supreme Court case, it's NRA, D as in Delta, B as in Bravo. It's Ohio Supreme Court out of 2011. And the case is virtually identical to this. I will give you the site. It is 950 Northeast 2nd 528, and also 129 Ohio State 3rd 104. And
if you could put that in a letter too, that'd be very helpful.
It would. And I came across it maybe at 1 a.m. this morning when I was staying up late working. But it was a statutory rape case where the law actually focused just on those under the age of, I think it was 13 there. Here it's under the age of 14. But virtually identical facts where it was consensual. And they said the statute basically failed no matter what. And these 13-year-olds were protected class. And that equal protection and vagueness and due process, it failed across the board for these children because you basically, no matter what, you cannot defend the case.
It's too bad we're not in Ohio.
Well, and so
it was one of the weird cases we came across. It was so on point. I had to bring it up to the court.
Actually, I believe we've seen that case.
I saw by the nod of my head, I figured so.
But I guess the other question is do you want to comment briefly on the jurisdictional issue?
And Your Honor, I will try to do that on my rebuttal for you. I know.
And if you want to talk about it then, that's fine.
Well,
but
I wasn't prepared to address jurisdiction. I know 5 years ago that was an issue that I brought up to the court, and I apologize. I'm not as well versed in the jurisdiction issue that you may want to be referring to, and I will look at my notes and see if I can on my time remaining.
Well, part of the issue is the Texas Supreme Court, how far are they going to go with importing criminal practice into this quasi-criminal situation? And I think we could tell you what we would do if this was a pure criminal case in terms of preservation of error from a habeas corpus application versus the direct appeal, or what happened at trial, and et cetera, et cetera.
I think, if I understand your question, I think that some of the authorities are split, if it's what you're getting at, in regard to writs of habeas corpus coming up from the trial court, and whether or not you can do a pretrial writ. Is that what you're referring to?
Well, I'm not even sure I understand how who would see a writ of habeas corpus that would come up here. I could tell you the answer if this was a purely criminal case.
Sure.
And maybe I'll ask the state the same question, but I don't know where we're going from, going forward on this.
Yes, sir.
Because I think it's somewhat uncharted territory.
It's been difficult cases to research because there's not a lot of guidance, but
We get to make the guidance here.
I hope so. And if the court wants me to get, I was reserving time. I can
Yes,
continue.
that's fine. Thank
Yeah.
you. Yes.
Thank you.
Help.
Good afternoon. May it please the court. I'm actually going to try to address Justice Hassan's question in the very beginning and Justice Payne's question at the very end. They kind of tie into each other about jurisdiction on appeal versus what was presented in the trial court. A caveat to essentially both of those questions is that it has to do with cognizability in pretrial writs, which as applied writs, pretrial writs are not cognizable. So essentially, even assuming there is a right to appeal in this case, or going to the question of preservation, this court still wouldn't be able to consider that because this was his amended pretrial writ was an as-applied challenge, and it wasn't something like double jeopardy or separation of powers.
And that's clearer in a pure criminal case.
Yes.
What are we to, what is to be done theoretically going forward in this case? Who would it go to?
Right. Does he have the ability to file a post-trial habeas writ?
Yes, there are. The answer to basically every juvenile question is it may possibly depend, and we don't know, in my humble opinion. But there are more post-adjudication juvenile writs. There's much more case law on that than there are pre-adjudication writs. Part of the issue is the specificity of the statutory right of appeal, which as this court knows, there is no constitutional right to appeal. There's a constitutional right to a writ. But the family code is extremely specific in which orders you can appeal, and civil law generally, as well as criminal law, they both have the general understanding that you don't get interlocutory appeals absent specific exceptions. And this essentially ties into that. So Justice Spain's question essentially is a ruling on a pretrial habeas writ a final order under civil law? The answer is I'm just not sure. There's a little bit of a split in authority. As I pointed out in my supplemental brief with CLZ kind of outlined that. There are a few jurisdictions, including the First Court of Appeals, that have essentially said no, an adjudication is essentially a prerequisite to appeal. You wouldn't be able to appeal essentially a standard pretrial habeas matter, something like a detention hearing or what we'd call bail writ on the criminal side. This is a little bit different in this case. This is just a very unusual structure into TVT
Which court
procedure.
would such an application for writ of habeas corpus, which presumably would look like something under the Code of Criminal Procedure, go to?
Correct. And although
I'm
Article
guessing
11,
not the Court of Criminal Appeals.
Exactly, yes. There is actually a Texas Supreme Court case, the name actually escapes me, but it's from the 1940s, and I can submit that to this court. But it was, the issue was a writ of habeas corpus from a contempt order, which is more generally what you might see on the civil side of things. And the appellate court tried to say, well, the habeas writ, that's a criminal matter. The Texas Supreme Court said, no, if it's a habeas matter that arises from a civil procedure or a civil case, it's going to be a civil matter. So I would think under that, habeas writs in a juvenile case should be considered civil matters because the rules of civil procedure apply, and the Family Code specifies only certain portions of the Code of Criminal Procedure apply to juvenile proceedings.
So it would come to us first and then go to the Texas Supreme Court?
I believe so, yes. And there are cases, post-adjudication writs where that was the procedure.
Chapter 11 of the CCP is the Family Code incorporates?
No, no, Your Honor. It incorporates the rules of evidence and the burden of proof for criminal, of course.
So
but I didn't see a specific incorporation of Article 11 in the Family Code. No, Your Honor. And that gets me back to, so that split as to essentially, that gets us back to cognizability, essentially, is whether the courts that have disagreed and said an adjudication order is not a prerequisite, that a writ ruling is a final appealable judgment, those essentially kind of follow the criminal context, which that's pretty clear. A pretrial criminal writ, you can generally appeal that unless it's not cognizable, which is the issue here. So cognizability essentially forecloses the need to even address jurisdiction, especially in this specific case where there was an agreed stipulation, so it's a plea bargain case, which makes it even stranger for appeal.
So could there be a post-conviction application for writ of habeas corpus?
I have seen...
As a creature of constitutional necessity, even though the Family Code isn't sending us to the Code of Criminal Procedure for help?
Specifically on the as-applied challenge that is not available prior to adjudication.
That would have to... No. If you apply preservation challenges, because as-applied challenges, at least in the criminal context, they have to be preserved. So essentially what would have needed to happen if you apply the criminal route or kind of incorporate that understanding, since writs are so much more common on the criminal side, essentially he would have had to have gone to a trial or put on any evidence. As this court was discussing, there was no evidence put on about, well, the complainant actually made me do this, or I didn't cause this conduct, which is the element of the offense that's at issue.
Who caused that? Was the trial court at all involved with denying the opportunity to present that evidence?
I didn't take from the record, I did not take that as a denial to put on the evidence. It was essentially a hearing on the motions and the writ that were already filed. I wasn't there for the hearing, so I don't know if there was a request to present any evidentiary matter or any evidence at this hearing to explain this is what or a proffer of I would testify to this from the respondent or from a witness.
So that might raise an issue of ineffective assistance then.
That is an issue for habeas,
but
possibly.
Is it authorized to go to any court for review, at least from a strict statutory standpoint?
The best I can interpret is from essentially the two tracks of thought on pretrial habeas as to whether you need an adjudication order to be able to get a writ, or you need to, or the writ itself is a separate proceeding like it is in criminal law. Under both of those theories, a post-adjudication writ would be just fine, because it would be either a separate proceeding, which the first court has already held that as well in RG, which is in our brief, or if an adjudication order is a prerequisite, then you already have that. So I think for post-adjudication writs, the question is a lot easier, because no matter which way you want to construe it is essentially, I don't want to call it a motion, but an issue that was raised as part of the underlying case in which the final order is the adjudication order versus it's its own separate proceeding and the ruling is the final order. So either way, a post-adjudication writ should be, I think under both of those theories, it would satisfy both of that to permit post-adjudication habeas. And there are more cases on post-adjudication writs than pre-adjudication writs, if that makes any sense.
So on our jurisdiction question,
Yes.
do you have, what is your strongest argument that this court does not have jurisdiction?
The strongest argument is going to come from the CLZ case that I cited in my supplemental brief and from the Family Code itself. 5601 is the statutory right of appeal. It specifically delineates which orders a juvenile is permitted to appeal, and writs are specifically excluded. Although the chapter does say this doesn't interfere with your right to obtain a writ of habeas corpus, it does not include a specific right to appeal the denial of a writ. Yes, that's correct.
Because
On the arguments raised during the habeas?
Yes, it would have to be a denial of relief.
because an interlocutory order, is that basically the argument?
That would essentially,
I mean, is
yes,
that-
if you follow that track, it would
Right.
essentially be an interlocutory order. It wouldn't be a final judgment.
So that would be following the precedents of the First Court of Appeals on RG, is that correct?
RG is a post-adjudication writ. It would be CLZ, Your Honor.
Okay,
Which
thank
is
you.
The 2022 case, the more recent case.
Thank
Your
you.
Honor.
So, here's my question on the interlocutory order aspect.
Yes.
So, this is post-adjudication though. We are in a post-adjudication world in this
Right.
case. So, it's not interlocutory, right? So, TBT had the right in the appellate process, which is what we're in right now, to bring challenges to the writ, the pretrial writ.
I think under both of those,
Okay.
the adjudication
So-
versus, yes.
So then,
yes.
let's assume that we're in the right posture to bring a challenge to the rulings that were made by the trial court under the pretrial writ. Is there any other argument you have regarding jurisdiction, that TBT did not preserve his arguments, during the
Yes.
pretrial writ phase?
Yes, yes, Your Honor. Moving, in addition to the cognizability issue that I discussed earlier, even if this court can consider jurisdictionally the writ, it's not cognizable, so you still wouldn't be able to consider his arguments in it. Pretrial writs are extraordinary writs, and they're reserved for very, very unique situations and shouldn't be used as essentially a premature appeal, which is why cognizability is such a
I
threshold
mean, this
issue.
is kind of a unique situation.
It is all the way around, Your Honor. But to your other point about preservation in general, no. The due process and the equal protection claims, those were essentially not preserved. The bulk of all of the arguments from all the motions and the writ was the statutory interpretation question that's already been addressed by the Supreme Court. It was essentially focusing on the accused's, quote unquote, capacity to commit an offense because they can't consent to sex under BW. All of the motions, that was essentially the entire argument, and in the pretrial writ, the facial challenge, the amended writ got rid of the facial challenge, so it would just be the as applied. And if you ignore the cognizability threshold or that issue, there's just, that's about as far as we get. And even if that was preserved, there's just no merit to it. It wasn't a specific equal protection claim. I don't think he mentioned equal protection in any motion, writ, or the hearing. And the due process complaint was the lack of opportunity to present a defense. But if we get to the merits on that, that's without merit. There is no right to claim that your victim cannot, or that your victim consented. That's not a fundamental right. If there's any other questions? All right, thank you.
Thank you. Rebuttal?
Yes, Your Honor. Your Honor, we have looked at CLZ. CLZ was, I believe, one of the basics of the denial of the writ was a failure to get a written order.
I'm sorry, I'm just having,
Sure.
I understand, and I'm just having trouble hearing you, so.
Yeah, no, I apologize. It's difficult to project.
I know.
Apologize. So CLZ was, at least my understanding of CLZ and the limited aspect of it, was the writ was denied due to there was no written order. There's a JCL case where it denied mandamus because there was a writ of habeas corpus, I believe, pending, which almost insinuates that the writ of habeas corpus would have the ability to come up to the appellate court, so mandamus was not proper.
Well, I mean, did they give a reason for the denial of the mandamus?
No, ma'am. Okay, they did. I think it was because there was a writ pending in the lower court, was my understanding of that. Furthermore, 5601 of the Texas Family Code does not close the door, and I believe it specifically states it does not close the door to the writs of habeas corpus. As for bringing up equal protection, there's cases out there that discuss you don't need to use the magic words if you discuss the issues in and of themselves, which we did. Equal protection, we clearly stated, or the applicant clearly stated to the trial court that you have two children of a certain age. We believe that certain age is a protected class. They would be treated differently, and although that goes into a vagueness argument and arbitrary enforcement, it encompasses within equal protection. And as such, we believe that the court understood the argument based on the transcripts with the trial judge, that he understood where applicant was going with that argument, so he could grasp the arguments, the legal arguments that were being made. So I believe the applicant preserved the issue, or the jurisdictional issue that you're referring to, based on that, at a minimum. Can I address anything else for the court?
No, I think we're good. You got a lot of time early, so.
I'm happy to discuss.
I guess I do have one question.
Sure.
So, do you agree that a post-trial writ is available to your client?
I believe a post-trial, yes. A post-trial writ, the cases I think we saw last night and looking at, just to refresh my memory on the writs of habeas corpus, I do believe that a post-trial writ of habeas corpus is available.
Okay.
I do think so.
All right. Thank you.
Yes. Thank you for your time.
Thank you. All right, in the matter of TVT, this case is submitted. Thank you for your hard work.